Okay. At the outset, I wish to thank you all for inviting me to this very important webinar. And it is my pleasure to be with you today. Uh, it's about being with the community of people that you identify with, and this is what makes me very happy. And I am going to share with you just s- little snippets of what actually happens in a court of law when you represent the SC and ST community. I have something written out, but before I go to that, let me tell you that as recently as 28th of May 2021, I was appearing in the High Court of Bombay through video conference in a matter which I will talk about at some length on behalf of the SC and ST community. And you will not believe it, but I was not even allowed to address the court. My voice was drowned out by a good many male lawyers. I happened to be the only woman addressing the court who effectively prevented me from addressing the court on my petition, where I had the right to audience, and all these people were representing the unreserved category, or what we call the open category, or what we call the upper castes, as interveners. So, what I want to tell you is that there are strategies used by people who represent the upper castes or the upper castes who which are not just legal strategies. They are strategies intended to demoralize you. They are strategies intended to drown your voice. They are strategies intended to put you down before because you happen to be a woman. And there is no end to what you see in a court of law. You are very comfortable here in this webinar. You are in a safe space, but you try entering the space of the courtroom because they know that the outcome of a case in court can change the course of our lives for the better. Now, having said this, I want to uh, go straight to the issue at hand. What is the immediate provocation for me to be at this webinar today? It was precisely the recent notification issued by the state of Maharashtra on the 7th of May 2021, which took me by complete surprise. The effect of that notification was that all posts that were reserved for the scheduled castes and scheduled tribes that were to be filled up by promotions from the reserved category were abolished, and henceforth promotions were to be done strictly in accordance with seniority, being determined on the date of recruitment into the service. Along with this sudden development, I raised the question as why would this be done in the year 2021 and on the 7th of May 2021? Only one answer presented itself to my mind, and that was on the 5th of May 2021, only 2 days before the Supreme Court of India had struck down Maharashtra government's flagship program of giving reservation to Marathas in the OBC category, significantly on the ground that they were not backward. Was this then an act of revenge? This is a question that many people in Maharashtra are asking. Do the SC and ST communities have to pay the price for the Supreme Court striking down reservations for Marathas? It
मैं
was an
एक
act of
पूछना चाहता हूँ।
appeasement. It was an act of appeasement, in my opinion, intended to tell the Maratha community, look, all these posts which were hitherto reserved for the scheduled caste and scheduled tribe will now be available to you in a general category, which we were not doing in the past. So this was the politics behind it. And there was more to the politics because when the reservations were made for Marathas in Maharashtra, it was the BJP government which was in power. And they had succeeded in having their law upheld in the High Court. This law was challenged in the Supreme Court and struck down. As I said, one of the grounds for striking down was that the Marathas are not backward. And the other ground was that after the constitutional amendment giving constitutional status to the OBC Commission, it was no longer open to states to tell us who are OBCs. This function can be performed only by the center. This has resulted in excessive centralization of the power to identify backward classes, a power which was hitherto available to all the states. And I think we should be thinking of that issue also very seriously. Now, let me come back to the notification of 7th May 2021. What was the impact of this notification? In my opinion, in effect, it reserves posts at the promotional level for SC and ST and makes them available to the open category in order of seniority. Seniority, as I said, being determined not by the date of entry into the cadre, but by the date of entry into the service. By one stroke of a pen, two constitutional amendments were done away with. The 77th Amendment, which added Article 16(4)(a), granting to SCs and STs the right to reservation and promotions, and the 85th Amendment, granting to scheduled castes and scheduled tribes consequential seniority when promoted. By one single stroke of a pen, the position as it obtained in the 1995 Indira Jaising judgment was restored, and the constitutional right to reservation and promotion through consequential seniority was invalidated. You see how easy it is to undo a constitutional amendment. This particular government resolution was not even placed before the cabinet. It does not have the imprimatur of the cabinet on it. It's just an GR signed by an undersecretary. Now let's go back to the genesis of the dispute. It was in 2018 that the state of Maharashtra decided, the High Court of Maharashtra decided in the Vijay Ghogre case that the state of Maharashtra had not complied with the Nagaraj conditionalities and hence struck down reservations. Significantly, the statute, the law under which these reservations were made was not struck down. So this brings us round and round and round and round and back to the Nagaraj conditionalities, which are what? Which are that there should be data for their backwardness, that there should be inadequacy of representation at promotional levels, that there should be data to show that these promotions had no impact on efficiency in administration. This judgment was appealed in the Supreme Court of India by the state of Maharashtra, which vigorously supported reservations and promotions. During the pendency of the appeal, the general judgment was decided, holding that it was not necessary to produce data for backwardness for SC and ST. And let me tell you, because by definition, SC and ST were backward. Let me tell you, I had appeared in the Jarnial case, and even if I may say so myself, I was largely responsible for ensuring that this particular conditionality was removed. Now, whereas a lot of people argued that the state could not, that the court could not decide on whether they were backward or not, because Article 340 of the Constitution of India mandated that only the president could decide whether a particular community deserved to be in the backward classes. I chose to put my argument on a higher level. And my argument was that when the president puts a scheduled caste community in the presidential order under Article 340, they do so on the ground that these communities have been hitherto considered as untouchable. So I think besides talking about backwardness, it was very important for me to talk about untouchability. And it was important to tell the court, I can't even begin to tell you how the bias of judges reflects in open court in the exchange between lawyer and judge. And as Dr. Mohan Gopal pointed out, One such bias is reflected in the Jarnial judgment when the court says at higher levels you don't need to promote SC and ST. And it was at that point that I turned round and told the judge, for your information, the President of India, who happens to be a scheduled caste person, was not permitted to enter the Puri temple. There was pin drop silence in the courtroom because the fact could not be disputed. What answer would you give to something like that? And so I persisted in saying that the president does put in the schedule castes which were formerly considered untouchable, and ultimately the court did hold that there was no need to prove backwardness. We are then left by the so called two other conditionalities. I have come to the conclusion that no matter what the SC and ST community does, they will never be able to comply with so called conditionalities. Newer and newer conditionalities will be invented. It, of course, shocked my conscience that the state of Maharashtra, which had consistently defended reservations in promotion in the Supreme Court of India in front of my very eyes, where reservation has been in existence in promotion since the year 1974, suddenly turned around in the year 2001 and scrap all reservations and promotions. How does this happen? In my opinion, it is because we have a very unclear understanding of what we mean by the constitutional right to equality under Article 14. In line with the fact that there is no clear understanding in the court, we also don't have a clear understanding of what is meant by Article 15, which mandates non discrimination based on sex, race, and caste, or any of these uh, markers. And this is what finally leads us to a collapse in Article 16 of the Constitution, 16.1, where there is no understanding of what exactly is meant by equality of opportunity in public employment. So, over the years, as we all know, there's been a systematic attempt to reduce our understanding of equality, of formal equality. This understanding would mean that a person belonging to scheduled caste and tribe and the upper caste are equal in terms of their opportunity in public amount of employment. This, in my opinion, amounts to making equality stand on its head. I believe that society functions through its networks, which are closed and do not permit entry by outsiders. These networks are based on the triple combination of caste, class, and sex. These networks are, so to say, genetically inherited. This is what accounts for dynasties in all our major institutions that we see in society. It operates within the legal profession, it operates in all professions, it operates in politics. I know of cases where litigation itself has been inherited by 5 generations of lawyers, all belonging to the upper caste. Where position, power, education, employment, and landed property all contribute to the availability of opportunity, I fail to understand how we can say that we have equality of opportunity in this country. If this be the position, then on what basis can we say that an upper caste person and a scheduled caste person must equally compete for a place in public employment? Now, the Constitution has its own solutions with full knowledge of the existence of these networks. Our Constitution makers drafted 14, 15, and 16 as a trinity of equality. And we need to read them together to understand the issue of equality better. Article 15 tells us that wherever there is discrimination, there can be no equality. That's how I read Article 15. Discrimination is the act of and the outcome of overt acts which push back a person from exercising all human faculties. Dr. Mohan Gopal read out a portion from the judgment in Jarnial, which is based on pure and simple bias. Bias, which is an aspect of discrimination. Discrimination itself is a barrier to self development and progress in the real world, as also in matters of public employment. And that is why I think Dr. Mohan Gopal reminded us so beautifully about what Mr. Nagapal said, that this is not a claim that we are making out of, asking for charity. It's not a claim to development. It is a claim to have our claims recognized. And this is what we need to understand. What are our claims on this nation? What exactly is the claim that we are making on this nation? So, as I said, discrimination is only the overt act by which our claims are being denied to us. And all that we are asking for is lift this barrier of discrimination, and we will then know how to take care of ourselves. Discrimination can only be undone by actively ending discriminatory practices. And one of the most obnoxious of discriminatory practices has been the practice of untouchability, which I said is the basis on which castes are included in the list. Historical discrimination, which is in some small measure was sought to be undone by the institutional device of reservation in 1604. India is unique in the world in providing for reservation in matters of public employment in its constitution for backward classes. No other country in the world has such a provision in its constitution. Rwanda does have a provision in its constitution making 50% reservation for elected representatives to be women. And thanks to it has proved that to be a measure where you will find in Rwanda more than 50% of elected representatives are women. No other country in the world, again, has the number of women in the political space as in Rwanda. We need to distinguish between reservation and affirmative action. It is not affirmative action. As one of the judgments in the Supreme Court tells us, it is like standing in a separate queue from the unreserved category. And there is no way that a person from the unreserved category can join the queue of the reserved category. Now, let me move to the issue of adequate representation. It get how it gets how does this enter the picture? As Dr. Mohan Gopal pointed out, it is a standalone right which we find in Article 16.4. Controversies have, I would like to draw your attention. It is my submission that we should not be called upon to provide adequate data for adequate representation at all. And the second conditionality in Nagraj should also be done away with. And my reasons are as follows. We know that as far back as 1995, we had a decision of the Supreme Court in Sabharwal versus State of Punjab. It held that reservations are to the post. This meant that in a 100-point roster, relevant posts will be reserved in accordance with the percentage fixed for SC and ST. Once that is done, the controversy of adequacy of representation would become irrelevant. All that we would have done is to ensure that the roster is properly maintained. Therefore, in my opinion, the second conditionality of Nagraj is a hoax. It's a smokescreen to prevent us from realizing the right to representation. Forget for a moment the word adequate. Let's say it's a right to representation, and we will come to what it means when we use the word adequate in addition to the word representation. But let me quickly come back to equality. I'll move a little faster because I know there are many speakers today. We all know that in state of Kerala versus Thomas, the court held that 16.4 is not a proviso or an exception to 16.1, and by definition, therefore, it ties in very neatly with Article 14 and 15 as well. This position was reiterated in the Indira Soni case, where the court held, and I quote, but that is only an emphatic way of saying, stating the principle inherent in the main provision itself. In our respectful opinion, the view taken by the majority in Thomas is the correct one. We too believe that 16.1 does permit reasonable classification for ensuring attainment of equality of opportunity assured by it. All the same, legislative anxiety of affirmative action by preferential treatment to a disadvantaged group lagging behind may not be doubted. Differences between reservation and preferential treatment is that in one group or class or collectivity is separately provided for and the competition is among them only, whereas in preferential treatment, the collectivity is part of the same group, but it is permitted some weightage due to social, economic, and any other justifiable reason. For purposes of achieving equality by result, Article 16 creates two compartments, one general and the other reserved, and that both are paired together. But preference is available in the same compartment. Validity of one depends on the constitutional sanction, whereas the second has to stand the test of reasonableness. For instance, the reservation of backward classes cannot be assailed as being violative of the constitutional guarantee, whereas preferential treatment can be upheld only if it is reasonable with nexus it seeks to achieve. Article 16, unlike Article 14, is a positive right to equal opportunity. Therefore, any preferential treatment shall have to be tested in the light of the constitutional objective of the articles which it seeks to achieve. That is what its nature, operation, and effect is. Reservation made for backward classes of citizens achieve the constitutional goal of achieving equality of opportunity for all. Same cannot be said for others. Any reservation for any other class could be, as already explained, contrary to the constitutional objective, thus invalid. Wards of military personnel, political staffers, etc., can be extended the benefit of Bennigan discrimination, as they would be cannot be extended as they would be violative of equality of opportunity. Now, this passage in my mind should put to rest for all times to come our understanding of equality, but unfortunately, it has not been so. And incidentally, in the Nagraj case, the running thread of reasonableness, which has to be shown for preferential treatment, was applied to reservations. I hope I'm clear. If I'm not clear, I would like to explain that proposition. The running thread of reasonableness, which is required to be shown in the case of preferential treatment, was applied when it should not have been applied to reservations in employment, which is a constitutional right. You cannot apply the test of reasonableness to a constitutional provision. Now, despite this, you will find that this position of law is not accepted by the Supreme Court repeatedly when it comes to the question of reservations and promotion. However, I had the privilege of arguing the case in Pavitra 2, where we cited the M. Thoman case, and it is to our good fortune that the Supreme Court accepted this proposition and held that Thomas' case had properly understood what was meant by equality. And the court said social justice is concerned with distribution of benefits and burdens. The Reservation Act of 2018 of Karnataka, in providing consequential seniority, furthers the vision of substantive equality and is valid. Now, this is the other confusion you'll find in judgments of the court. They're unable to distinguish between what they call affirmative action a concept borrowed from the US Constitution and its jurisprudence and reservations. And the court says while affirmative action may be permissible under 15.4, while dealing with 16.4, there are constitutional obligations in place. Interesting quote from there, I'll read it. Clause 4 of Article 16 contains an enabling provision. Mind you, I have a quarrel with the word enabling. Enabling. Please note, please all of you make a note, the word enabling does not occur in Article 16. It's nowhere mentioned in Article 16. And yet it recurs constantly in every judgment of the court. Clause 4 of Article 16 contains an enabling provision to empower the state to make reservations in appointments or posts in favor of any backward class of citizens, which in the opinion of the state is not adequately represented in the services. Clause 4A contains an enabling provision, which, mind you, the court is overlooking the word shall in 4A. Provisions which allow the state to provide for reservations and promotions with consequential seniority in posts or classes of posts and services under the state in favor of SC and ST. Clause 4A also uses the expression which in the opinion of the state are not adequately represented in the service under the state. Now, after that, we have a long discussion in Nagaraj, in Pavitra 2, which in the interest of brevity, I will skip over. But the court reiterates at para 113, the first principle is that executive arm of the state is aware of the prevailing conditions in the state. What does this mean? It means that before making a reservation, the state knows that in my state, what is the representation of SC and ST in the promotional level. And then the court says this is the privilege of the legislature. Now, let me come to the issue of representation itself. And although Dr. Mohan Gopal, in his opening comments, said the issue is not representation, the issue is my claim. But in my opinion, these two issues are inextricably linked with each other. Let's give it a closer look. The critical part of Article 14, namely reservations for those in the opinion of the state are not adequately represented in the matter of public employment, 16.4 creates what Dr. Gopal has described as a fundamental right to adequate representation. For a moment, I do not wish to emphasize the word adequate. I'll come back to it in a minute. Ingenious lawyers and judges have turned this proposition on its head, and far from making it a right, have reduced it to a barrier to reservations. So we need clarity that over and above the right to representation, there is a right to adequate representation of SC and ST in public employment. Once the right to representation is seen as a right and not a limitation on equality, the question then becomes, what do we mean by the word adequate? Moreover, these provisions no longer remain quote unquote enabling, but enter the realm of rights. I really don't know where the word enabling has come from. As I told you, it's not in 16.4. And as a practicing lawyer, it's my duty to evolve remedies. And therefore, I say that once we enter the realm of rights, a mandamus can at any time follow for the realization of our right or for the removal of barriers to our rights. And so we now come back to the expression adequate. It is here that we have to assert loudly, if at all we wish to succeed, that adequacy can be judged by the percentage of the people in the population. And this is why, from time immemorial, the central government has always given 15% reservation to SC and 8% or 9% to ST, depending on the ST population. Certain states give more than this for tribals because they have a larger tribal population. As we saw, Jernial does not accept this proposition without really explaining why this proposition is not accepted. But if we want to come out with a strategy for challenging Nagraj on the other two conditionalities, we need clear answers to these uh, concepts. Concept of adequacy needs to be understood clearly, and the nature of the right. So I would say representation is a goal in itself. Adequacy of representation is a constitutional goal in and of itself. And I'm once again reminded about the passage that Dr. Gopal read out from Mr. Nagappa, where he said, "Don't take our ignorance or our deafness or our dumbness for granted. A claim is a claim." And therefore, that claim that we wish to have our fair share in public employment and in all organs of governance will remain a claim which has to be articulated in a court of law. And so, if we were to come back to the 40-point roster or the 100-point roster, in my opinion, after Sabharwal, there can be absolutely no controversy over the question where the court said reservation is to posts and not to vacancies. There can never be any question of any overrepresentation, which I suppose is the bugbear of the open category. When they question and ask for data on adequacy of representation, what they're really saying is, look, aren't you people already overrepresented? That's why you want data on adequacy. The state has simply to show that they have a roster, which they maintain, in which certain posts are filled in for reserved and unreserved category in accordance with the percentages fixed under their laws, rules, and regulations. On the other hand, questions of underrepresentation may arise when a post in a reserved category is not filled up on the ground of non-availability of suitable candidates, and there is a carry forward on the roster. So if at all these questions arise, they will be questions of underrepresentation and not overrepresentation, where different kind of remedies will be called into question. Similarly, the question over representation would not arise, and the second conditionality in Nagraj will have to be thrown out of the window. Then, of course, you reach the third conditionality, that is of efficiency in administration. I can do no better than read out from Pavitra, where it was clearly articulated. And I read para 152, the Constitution does not define what the framers meant by the phrase efficiency of administration. Here it is. These phrases are not defined in the Constitution, and over the years, upper caste judges have put meaning into them, upper caste lawyers have put meaning into them to suit partisan aims. Article 335 cannot be construed on the basis of a stereotypical assumption that roster point promotees drawn from SC and ST are not efficient, or that efficiency is reduced by appointing them. This is stereotypical because you see the word stereotypical refers to discrimination and bias. What is a stereotype? A stereotype is a biased opinion about a particular person because it makes deep-rooted social prejudice. The benchmark for the efficiency of administration is not some disembodied, abstract ideal measured by the performance of a qualified open category candidate. Efficiency of administration in the affairs of the union or of the state must be defined in an inclusive sense where diverse segments of society find representation as a true aspiration of governance by and for the people. If, as we hold, the Constitution mandates realization of substantive equality in the engagement of fundamental rights with the directive principles, inclusion together with the recognition of plurality and diversity of the nation constitute a valid constitutional basis for defining efficiency. Our benchmarks will define our outcomes. If this benchmark of efficiency is grounded in exclusion, it will produce a pattern of governance which is skewed against the marginalized. If this benchmark of efficiency, just pause here for a moment. What then is the benchmark of efficiency? The benchmark of efficiency would be whether you have given proper governance to the marginalized sections of society. So when governments do their study on efficiency, what are they supposed to show to the court? They're supposed to show to the court that our Ministry of Social Welfare was able to do A, B, C, D, E. Our Ministry of Power was able to do A, B, C, D, E. And this is where, when you have scheduled caste and scheduled tribe people employed in these positions, the ordinary person feels a sense of identity, a sense of connectedness, a sense that I have somewhere to go with my grievance. And as you know, all ministries are now supposed to put grievance procedures in place. But if the grievance procedure goes to a monster who is biased, what is the purpose of that grievance procedure? So the court continues, otherwise, our past will haunt the inability of our society to move away from being deeply unequal to one which is founded on liberty and fraternity. Hence, while interpreting Article 335, it is necessary to liberate the concept of efficiency from a one-sided approach which ignores the need for and the positive effects of the inclusion of diverse segments of society on the efficiency of administration, the union and the state, establishing the position of the SC and ST as worthy participants in affairs of governance is intrinsic to an equal citizenship. Pause here. Therefore, our right to adequate representation is our right to equal citizenship. Equal citizenship recognizes governance which is inclusive but also ensures that segments of our society which have suffered a history of prejudice, discrimination, and oppression have a real voice in governance. Since inclusion is inseparable from a well-governed society, there is, in our view, no antithesis between maintaining the efficiency of the administration and considering the claims of SC and ST to appointments of service and posts in connection with the affairs of the... I would imagine that with this judgment, the third conditionality of Nagraj also gets destroyed. The court, of course, goes on to quote Amartya Sen. I will not bore you with those quotations right now. They're readily available in the judgment, and I would urge you to take that judgment seriously. And then we come to what? Now, my question is, as I conclude, and yet, despite this constitutional outcome in Pavitra 2, we find no mention of the judgment of Pavitra 2 in the subsequent judgment of Manoj Kumar. This not only goes counter to the law of precedent binding on coordinate benches, but it points to a more fundamental question. What, after all, is the meaning of equality of opportunity? Have our judges understood it? I repeat, it is obvious there is no understanding of this question in the Supreme Court of India. Moreover, constitutional adjudication cannot be determined on words such as enabling, words in any event which have been coined by the Supreme Court of India, on which to hang decades of decision making by the courts. I need to sound a word of alarm over here. My colleagues at the bar, who traditionally represent non-reserved categories and often drown out my voice, always argue now that equality and reasonableness are part of the basic features of the Constitution post Nagraj. I have heard the lawyer who argued the Nagraj case. He appeared against me in Pavitra, and this was his main argument. His main argument was equality and reasonableness are now part of the basic features of the Constitution. It was like holding out a threat to the judges that since Nagraj has held that these are the conditionalities, you cannot do anything otherwise. Now, in the past, we have been told that we are violating the right to equality of the unreserved category. In future, we will be told that we are acting contrary to the basic features of the Constitution. And therefore, I conclude by pointing to the dangers ahead. As a lawyer practicing in this field of work on behalf of the reserved categories, I already told you how my voice was drowned out before the High Court while challenging the GR of 7th May 2021. I would say that we are faced by a primordial challenge of bias, of stigma, and of the ever present practice of untouchability and of atrocities. I was speaking to my colleagues who appeared with me in the High Court of Bombay, and they all agreed that the existence of atrocities is a very real marker. And we were both discussing this, that we should tell the court, why don't you add to your list the collection of data on atrocities against scheduled castes and scheduled tribes before you accept any argument that there should be no reservation in employment and in promotions for scheduled castes and scheduled tribe, and use that as a benchmark to decide whether there has been equality of opportunity. Thank you for your patience. I'd like to stop here and would be delighted to listen to the others and get feedback.
Thank you very much, Madam Indira Jaising, for a really wonderful, masterful survey of the crisis facing the law on jurisprudence, that it is actually being attacked and hijacked and sabotaged in our country. And I think your intervention will help all of us realize what the correct position is on law. I'm very much in favor of adequate representation as a fundamental right, but actually adequate representation is typically something that is assured by the governing class to those who are not represented. But the irony is 85% of India is forced to ask for adequate representation from the 15%. So I think we both agree that adequate representation is important for the majority and for the minority. But what Mr. Nagappa was reminding us was that we are, as he said, the aboriginal people of this country, and it is what we want is our claim and our rights, and this is not any favor to us. This is what is due to us as 85% of India. So thank you very much for reinforcing all those points brilliantly.